Important judicial decisions. Welcome to my channel GS Current Law. We are discussing some important judgments today. Deepak Yadav and another versus State of Uttar Pradesh and another 2025 SC. The Supreme Court held that trial courts must form independent judicial satisfaction before taking cognizance or adding charges, not act mechanically on complainants' affidavits. Courts are required to examine the complete case diary under Section 172 CRPC, including all witness statements under Section 161 CRPC, and also review any material that may have been suppressed. Police must furnish the entire investigation record, conduct further inquiry if necessary, and submit a fresh report within 6 weeks. The judgment ensures that cognizance is based on proper investigation materials, not incomplete or biased records, reinforcing fairness and accountability in criminal trials. Gautam Dham Cooperative Housing Society Limited versus Funds and Properties of Parsi Panchayat, Bombay and others, 2025 Bombay HC. The Bombay High Court ruled that the limitation period under Order 8 Rule 1 CPC begins only after the defendant receives both the summons and a copy of the plaint. It accepted that the delay in filing the written statement occurred due to an advocate's office lapse, not negligence of the defendant, a society run by honorary members. Holding that a litigant should not suffer for a lawyer's mistake, the court found sufficient cause for delay, condoned it, and directed the written statement to be taken on record. The ruling stresses that procedural rules must serve justice, not defeat it on technicalities. Sanjay D. Jain and others versus State of Maharashtra and others, 2025 SC. The Supreme Court held that vague and general allegations in an FIR, even if taken at face value, do not make out any offense and justify quashing of proceedings. The court found that allegations of cruelty under Section 498 AIPC lacked essential ingredients such as intent to cause grave injury or drive the victim to suicide. Citing State of Haryana versus Bhajan Lal 1990, it held that the FIR against the in-laws should be quashed while proceedings against the husband could continue. The judgment safeguards against misuse of criminal law and reinforces that specificity in allegations is essential to sustain prosecution. Meenakshi Tyagi versus Union of India and another 2025 Delhi HC. The Delhi High Court reaffirmed that service matters of AIIMs fall within the exclusive jurisdiction of the Central Administrative Tribunal, CAT, following the ruling in L. Chandrakumar versus Union of India, 1997. The court observed that filing writ petitions in the High Court, despite clear jurisdictional limits, amounts to forum shopping and wastes judicial time. It cautioned that the court may soon impose costs, even at the withdrawal stage, to deter such conduct. The court also directed that a copy of its order be sent to the Delhi High Court Bar Association to raise awareness. The petition was dismissed with liberty to approach the CAT, reiterating the importance of jurisdictional discipline. Akkineni Nagarjuna versus X and others, 2025 Delhi HC. The Delhi High Court found prima facie that defendants had unauthorizedly used the actor Akkineni Nagarjuna's name, image, and likeness, including in pornographic and derogatory contexts. The court held that such misuse violates the plaintiff's personality rights, damaging both his dignity and commercial goodwill. Citing Amitabh Bachchan versus Rajat Nagi 2022 and Aishwarya Rai Bachchan versus linked to aishwaryaworld.com 2025, the court reiterated that personality rights deserve strong judicial protection, especially against AI-enabled misuse. It held that such conduct constitutes passing off and misrepresentation, causing public confusion and reputational harm. Ashok Kumar Tripathi versus State of Madhya Pradesh 2025 SC. The Supreme Court upheld the compulsory retirement of a police officer found intoxicated while on guard duty, observing that such conduct is incompatible with police discipline and public trust. Referring to Union of India versus KG Soni 2006, the court reiterated that interference with disciplinary punishment is warranted only when it is perverse or disproportionate. It also warned against the digital intoxication of police personnel, excessive use of mobile phones and social media while on duty, and recommended training and supervision mechanisms to curb it. The ruling highlights the importance of vigilance, discipline, and professional integrity in law enforcement. M. Fur Sharma Trading Company versus Union of India, 2025 Delhi HC. The court reaffirmed that under Section 171 of the CGST Act, the benefit of GST rate reduction must be passed to consumers through price reduction, not by increasing product quantity or offering free goods. Relying on Reckitt Benckiser India Private Limited, it held that maintaining the same MRP despite a GST cut amounts to profiteering and consumer deception. The court directed transfer of 555,126 rupees per to the Consumer Welfare Fund, while dropping penalty proceedings since they arose before Section 171, 3A came into force. This case emphasizes consumer welfare and honest tax benefit transfer under GST law. Atul Dini and another versus the District Registrar and others 2025 Kerala HC. The Kerala High Court held that software limitations cannot override statutory formats prescribed under the Special Marriage Act 1954. The court observed that the fifth schedule mandates inclusion of the date of celebration of marriage in the certificate. Since the Pearl software used by authorities omitted this field, the court directed immediate correction and ordered issuance of a new certificate including the actual celebration date. It distinguished between solemnization and registration, emphasizing that omitting the celebration date defeats the purpose of Section 15. The ruling reinforces that digital governance must comply with statutory mandates, not dilute them.